Mr. Chairman.
Senator Cruz.
If I might pose a question to the senior senator from California. In your response to Senator Cornyn, you mentioned that there's some 100 pages of the bill that specify particular firearms that if this bill were passed, Congress would have deemed prohibited. It seems to me that all of us should begin as our foundational document with the Constitution. And the Second Amendment in the Bill of Rights provides that the right of the people to keep and bear arms shall not be infringed. The term, the right of the people, when the framers included it in the Bill of Rights, they used it as a term of art. That same phrase, the right of the people, is found in the First Amendment, the right of the people to peaceably assemble and to petition their government for redress of grievances. It's also found in the Fourth Amendment, the right of the people to be free from unreasonable searches and seizures. And the question that I would pose to the senior senator from California is, would she deem it consistent with the Bill of Rights for Congress to engage in the same endeavor that we are contemplating doing with the Second Amendment in the context of the First or Fourth Amendment? Namely, would she consider it constitutional for Congress to specify that the First Amendment shall apply only to the following books and shall not apply to the books that Congress has deemed outside the protection of the Bill of Rights? Likewise, would she think that the Fourth Amendment's protection against searches and seizures could properly apply only to the following specified individuals and not to the individuals that Congress has deemed outside the protection of the Bill of Rights?
Would the Senator yield for a question?
Let me just make a couple of points in response. One, I'm not a sixth grader. Senator, I've been on this committee for 20 years. I was a mayor for 9 years. I walked in, I saw people shot. I've looked at bodies that have been shot with these weapons. I've seen the bullets that implode. In Sandy Hook, youngsters were dismembered. Look, there are other weapons. I've been I'm not a lawyer, but after 20 years, I've been up close and personal to the Constitution. I have great respect for it. This doesn't mean that weapons of war, and the Heller decision clearly points out 3 exceptions, 2 of which are pertinent here. And so you know, I mean, it's fine you want to lecture me on the Constitution. I appreciate it. Just know I've been here for a long time. I've passed on a number of bills. I've studied the Constitution myself. I am reasonably well educated, and I thank you for the lecture. Incidentally, this does not prohibit, you use the word prohibit, it exempts 2,271 weapons. Isn't that enough for the people in the United States?
Mr. Chairman.
Do they need a bazooka? Do they need other high-powered weapons that military people use to kill in close combat? I don't think so. So I come from a different place than you do. I respect your views. I ask you to respect my views.
Mr. Chairman.
Senator Durbin, it's not.
Mr. Chairman, I can't add anything to that.
Okay. Senator Cruz.
Mr. Chairman, I would ask yet another question of the senior senator of California. I think nobody doubts her sincerity or her passion. And yet at the same time, I would note that she chose not to answer the question that I asked, which is, in her judgment, would it be consistent with the Constitution for Congress to specify which books are permitted and which books are not, and to use the specific number?
The answer is obvious, no.
And if I may ask...
Could we keep on the... and I appreciate we have a discussion on books. I know that they have that in your state of Texas, where your educational boards tell people what books they should or should not read in their schools, something that we would not do in Vermont, but, you know, we're not going to talk about your right.
Well, yeah.
But let's stick to guns. And I know Senator...
Mr. Chairman, I appreciate your acknowledging that the state of Texas allows books. I would specify a little more broadly.
Child pornography books? Child pornography? Protected by the First Amendment?
It's obvious that there are different tests on different amendments. And I think what the senator is going to point out was something that didn't occur to me at the moment. There are certain kinds of pornographic materials that would not be covered by the First Amendment.
And is it the view of the senior senator from California that Congress should be in the business of specifying particular books, or for that matter, with respect to the Fourth Amendment, particular individuals who are not covered by the Bill of Rights.
Sir, Congress is in the business of making law. The Supreme Court interprets the law. They strike down the law, they strike down the law. The tests in Heller, with respect to unusual weapons and two other things, I think do not cover, in other words, they cover an exemption for assault weapons. And if this is brought up before the court, if it should pass, I'm sure that argument will be made.
Senator from Illinois,
That's exactly the point. The senator knows, having attended law school and professes to have some experience in the Constitution, none of these rights are absolute. None of them. And the Heller decision goes specifically to the question of this amendment and tells us, when they were asked in the Heller decision, a panel, Heller 2, a panel of Republican-appointed judges rejected a Second Amendment challenge to D.C.'s assault weapons ban and magazine limits. A Second Amendment challenge. The D.C. Circuit Court held that such laws, quote, do not effectively disarm individuals or substantially affect their ability to defend themselves. I could go on, but I think the senator from California has made this case.
Clerk will call the roll. Senator Cruz.
Thank you, Mr. Chairman. I think all of us understand the passions that this topic elicits. But in my view, decisions in this body on everything, and especially this topic, should be driven by facts and the data and by the Constitution, not by passion. So I'd like to make 4 points briefly. Number one, machine guns are already functionally illegal. When this topic is discussed in the public forum, a great many people, when they hear the phrase assault weapon, believe that what is being discussed is fully automatic machine guns. Senior Senator from California made reference to an AK-47, I believe wielded. AK-47 is a fully automatic machine gun that is functionally illegal today. Tragically, gang members don't tend to follow gun laws. Number two, this bill, the data demonstrate, would be singularly ineffective in preventing violent crime. That, I think, is not surprising because, as the hearings on this bill demonstrated, the weapons that would be prohibited by this bill are functionally identical to semi-automatic deer rifles, millions of which are in circulation. And this bill targets cosmetic features on guns, cosmetic features that at the end of the day make the guns appear scary, but does not alter the basic mechanism. And I would note that we don't have to hypothesize about the effectiveness because we in fact have seen what happens when a very, very similar bill is in effect. The prior assault weapons ban was in effect for a decade. 3 times the Department of Justice funded studies on that assault weapons bill, and 3 times the studies were not able to find any statistically significant impact on violent crime as a result of the assault weapons ban. That's 3 studies in a row, which is very difficult to get away from. And indeed, since the assault weapons ban expired, we now see murders by rifles are roughly half today what they were when the assault weapons ban is in effect. So this is not a law that I think has any reasonable prospect of reducing violent crime, something I know everyone on this committee would like to see violent crime reduced. Indeed, I would suggest, as my third point, that if the real objective is reducing violent crime, we should be devoting our time to far more effective steps. We should be devoting our time to laws that target violent criminals. We should be devoting our time to laws that improve the NICS background check. We heard testimony that 18 states right now have submitted 100 or fewer mental health records to the background check program. That's a serious problem. I would note my home state of Texas has submitted over 200,000 mental health records to that background system. And I fully expect to support on the floor legislation that is targeted at violent criminals and not at law-abiding citizens. Indeed, if we wanted to go further and really consider significant steps to stop violent crime, I would suggest we could consider legislation or a constitutional amendment to alter or repeal the exclusionary rule in criminal proceedings. Now, there is a rule that consistently excludes evidence of guilt from violent criminals and has resulted in violent criminals being freed over and over and over again. If the passion that is focused on this issue right now were targeted at preventing violent crime, I would suggest considering the impact of the exclusionary rule would be a far more fruitful area for actually stopping violent crime. Because I too, as many of the members of this committee, have worked in law enforcement for many, many years, have dealt with victims of crime, and think we need to be serious about protecting Americans from violent crime with every tool at our disposal. My fourth and final point is that the Constitution, in my opinion, should be the touchstone of everything we do. Some have suggested in this hearing that the role of Congress is to pass laws and it's up to the court to consider constitutionality. I would point out that every one of us takes an oath to defend the Constitution.
Thank you for the lecture.
And that is a fundamental obligation of every member of this body. There has been some suggestion that Heller would allow this regulation. I would point out that I am not unfamiliar with the Heller case. Indeed, I represented 31 states before the U.S. Supreme Court in the Heller case. So I have an intimate familiarity with that case, having been an active part of litigating it and winning 5-4 before the Supreme Court. And what the Supreme Court said in Heller, it did say there are some restrictions on the Second Amendment that are permissible. And for example, it specifically identified the current prohibition on fully automatic machine guns. But it also said that weapons that are in common use, such as, in that case, handguns, were the principal issue being discussed. And the same arguments that have been suggested here about why so-called assault weapons can be banned were made by the District of Columbia in Heller for why handguns could be banned. And the Supreme Court said, no, if they're in common use for self-defense, they cannot be banned consistent with the Second Amendment. We have heard testimony that there are some 4 million weapons that would be covered by this bill. I would suggest on any measure, 4 million weapons qualifies as in common use, and so under the terms of Heller, they cannot constitutionally be prohibited. The final point I would make on the Constitution is some have pointed to public opinion polls. In my view, the Constitution is particularly important when the Bill of Rights is unpopular. That was the entire purpose of the Bill of Rights. When our rights are popular, we don't need the Constitution. The purpose of it is to stand for the rights of the minority when the majority is acting to strip their rights. And I would note the senior senator from New York asked about other rights. I think we should be vigorous in protecting every right in the Constitution. Just last week, a number of us spent some 13 hours on the floor of the Senate defending the Fifth Amendment, and in particular, the right of Americans not to be denied their life without due process of law. And indeed, Senator Rand Paul and I have introduced legislation to make clear that the United States government cannot use a drone to kill a U.S. citizen on U.S. soil if that individual does not pose an imminent threat. And I would certainly welcome support from any of my colleagues on the other side of the aisle on that important protection of the Fifth Amendment just this week.
I don't want to, and will not cut the senator off. He's made the 5 of his 4 points.
Mr. Chairman, I would...
But we are going to have a vote in a few minutes, and I would ask him to, and I'll say if he wants to make a longer one, and I appreciate the lecture of what we're supposed to do as senators opposing the Constitution. I've been doing it for 38 years, but I'm always happy to have the reminder from somebody who's been here for
Mr. Chairman.
probably not quite as long, but I'd like to let some of the others,
But
if you don't mind.
I asked the gentleman a
Mr.
question.
Chairman, if I could have the 60 more seconds to conclude.
Go ahead.
Okay, I'll do it later. Yeah, okay. He's got 60 seconds.
Likewise, earlier this week, this committee voted to fund a study of the impact of films and video games on violent crimes. And I would note that I voted no against that as well, because I believe in the First Amendment, I believe in the Second Amendment, I believe in the Fifth Amendment, and I would suggest that every one of us has an obligation to the Constitution. I will happily welcome support from anyone who wants to stand and fight for the Constitution, because in my view, That should be our principal responsibility and obligation. Thank you, Mr. Chairman.
I thank the senator.